making sure we understand the proper way to apply the Heller methodology, which is really now the Bruin methodology of text first, historical tradition of firearms regulation second, is very important. And I have to give credit where credit is due. The United States Court of Appeals for the Ninth Circuit did a wonderful job in the United States versus Duarte breaking down this in even greater detail than I have on this channel. So I want to discuss this because I think this is helpful to you to understand this methodology, which at the end of the day is extremely helpful for protecting our right to keep and bear arms against the anti-gun lobby. Let's talk about Duarte, specifically the lessons we can glean from this excellent job of judging by the Ninth Circuit. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, we've talked briefly about the United States versus Duarte case, which is a decision by a three-judge panel in the United States Court of Appeals for the Ninth Circuit, 2-1 victory in support of the Second Amendment that says that federal gun control statute 18 U.S.C. 922 G1, which is the so-called felon in possession statute, is unconstitutionally applied to nonviolent felons because felons, as American citizens, are part of the people, and there's no historical analog law going back to the time of the founding that would say that nonviolent felons would lose their gun rights for literally the rest of their lives. Now, the methodology applied by the Ninth Circuit panel really did track the Bruin methodology, the NYSERPA versus Bruin methodology of look at the text first. If the plain text is implicated by virtue of the gun control statute or the conduct that's anticipated to be engaged in by the plaintiff or the Second Amendment defendant, then the burden shifts to the government to show a long-standing, unbroken tradition of some sort of firearms regulation that is analogous to the modern-day gun control law. Now, I thought that this decision by the Ninth Circuit was very powerful in many respects, and I think we want to spend a little bit of time breaking it down because I think it will help you deal with other cases. Again, although the United States versus Duarte case deals with the felon in possession statute 18 U.S.C. 922 G1, the federal gun control statute that says that, I think the methodology, of course, is applicable to all Second Amendment cases as well as it's supposed to be, according to the Supreme Court, and it's helpful to understand how this works. So let us talk about what the Ninth Circuit panel did and what we can learn from it. To begin with, they start off with the obvious, that you start with the plain text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. This is a pre-existing right. That's why it's written the way it is. The right of the people to keep and bear arms shall not be infringed presupposes the existence of the right of the people to keep and bear arms. It did not create a right. It codified, if you will, a pre-existing right to keep and bear arms in 1791 when the Second Amendment was adopted. Now, let's talk about the plain text. We don't ever want to gloss over this because remember what the anti-gun movement wants to do is they want to elevate all historical questions, including things like the in common use test by Americans for lawful purposes dealing with gun ban cases. They want to elevate things like virtuous citizen, law-abiding citizen, all sorts of other historical things at most. They want to elevate all those issues into the text of the Second Amendment. And the reason why they want to do that, as we've talked about, is once the text is implicated, the burden shifts to the government, and the government bears the burden to come forth with historical analog laws of firearms regulation that are so long-standing they go back in an unbroken tradition to the time of the founding. So this is very, very, very bad for the government because the government never wants the burden to be on them. They want to force the burden to be on the Second Amendment proponents at the textual level. So with that said, the Ninth Circuit panel did a very good job here pointing out that the plain text has to be implicated first. But then I thought this is very smart of them, and I thought of it conceptually, but not in this kind of detailed way. They said, really, the textual level involves three questions at the text. The first question is, who are the people? Who are the people involved? So, like, the right of the people to keep and bear arms shall not be infringed. So the first question is the person asserting a Second Amendment right part of the people? Now, if you're an American citizen, you undeniably a part of the people. I think if you're a green card holder, you're undeniably part of the people. Illegal aliens, I'm sorry, are not part of the people. That will never be upheld by the Supreme Court. We could do a whole video on illegal aliens, but undeniably, illegal aliens will not be part of the people. It's just not going to happen, nor do you want that, by the way. Illegal aliens can be deported in an instant. They obviously don't have any Bill of Rights like Americans do, and the Supreme Court has never said otherwise. So anyway, again, illegal aliens we'll deal with separately in a separate video, but the bottom line is they're not part of the people. They don't have Second Amendment rights. I don't care what anybody says. The Supreme Court will never agree with that. Just textually, they're not part of the people. But anyway, let's go back to the Duarte decision here. So again, the first question is, who are the people? The second question is, what is the arm involved in the controversy? And last but not least, what is the proposed course of conduct by the Second Amendment proponent? And does that implicate the right of the people to keep and bear arms? So again, the three questions are, who is the people? Second question is, what is the arm involved? Is it an arm? And then the third question at the textual level is, what is the proposed course of conduct by the Second Amendment proponent? So again, at the first level, we know that the Supreme Court has repeatedly said that the people, in the right of the people to keep and bear arms, consist of all American citizens and others with a ongoing relationship, close enough relationship to our country, which I think would involve green card holders, permanent legal residents here that may not be American citizens, but they're permanently here. I think that is the totality of who the people are that would have Second Amendment rights. Then the second question at the textual level, according to the Duarte decision by the Ninth Circuit, is arms. Are you dealing with an arm? And we know the Supreme Court in Heller says that an arm is to be broadly defined as anything that can be used offensively or defensively. That could, of course, involve all firearms, but it could also involve, let's say, contact weapons, knives, Bowie knives, could involve butterfly knives, could involve batons, nunchucks, contact weapons, if you will. These are all forms of arms that could be used offensively or defensively. And yeah, I think body armor also would fall within this definition, because if you look at the time of the founding, there are references to body armor being considered an arm because it can be used defensively. But again, we can talk about body armor in a separate video. So again, persons, all American citizens are part of the people. Anything that can be used offensively or defensively for self-defense or otherwise is an arm. And then the third question at the textual level that the Ninth Circuit said in Duarte is, what is the proposed course of conduct by the Second Amendment proponent? Now, in the Duarte case, the individual said, effectively, I just want to be able to possess arms. I'm a nonviolent felon, and I think that 18 U.S.C. 922 G1 is unconstitutional as applied to me. I'm a nonviolent felon. There's no evidence that a nonviolent person could be denied his ability of self-defense with arms. I should have the right to possess, and the course of conduct discussed here is the mere right to possess firearms. So in the Duarte case, Mr. Duarte is an American citizen, so he's a part of the people. He wants to possess handguns and rifles, so it involves arms, in this case handguns. That's what involved. Duarte was a handgun case, and his proposed course of conduct was simply to possess them, which falls within the right of the people to keep, which means to possess, and to bear, which means to carry. To keep, to possess, to bear, to carry in public, okay? So he's part of the people. It involves a handgun, which is an arm, and his proposed course of conduct is to possess it and possibly to carry it outside the home. So obviously the text has been implicated. Because the text is implicated, as the Ninth Circuit says, the burden then shifted to the government, in this case, the Merrick Garland, Joe Biden Department of Justice, to justify that nonviolent felons can lose their right to keep and bear arms for life by virtue of nonviolent felonies. Now, this is extremely important, what I'm about to say about this nonviolent felony statute. This is something that very few people fully appreciate, unfortunately. When you and I think of the word felon, naturally we think of people that are very, very bad. Gangbangers, drug dealers, murderers. That's what we think of felons. These malum in se, which means evil in and of itself crimes, murder, rape, robbery, burglary, evil stuff that everyone can get on board with, that's bad. But the reality is, in modern times, the definition of felony has been extended to all sorts of insane things. In fact, then Judge Amy Coney Barrett when she dissented in a famous case of Cantor versus Barr, when she sat on the Seventh Circuit Court of Appeals, she pointed out, and this is very interesting, that some of the quote-unquote felonies that now exist in American life, and she only gave a couple of absurd ones, involves selling pigs without a license in Massachusetts, redeeming large quantities of out-of-state bottle deposits in Michigan, and countless other things, including mail fraud and the like. So Justice Barrett, when she was a judge, says, everything is a felony now. This is simply absurd. So at one level, keep in mind that all sorts of things are now felonies today that at the time of the founding would be viewed as maybe at most misdemeanors. That's the first thing. Now here's the thing, though, that is lost on most people when it comes to understanding what the federal government interprets the word felony to mean in the course of interpreting 18 U.S.C. 922 G1. Very important to understand this. A felony that will get you barred for having the guns for life, or a misdemeanor, which is a qualifying felony essentially, is really if something is labeled a felony and you may not, but you could go to jail for more than a year, you lose your gun rights for life. You hear what I just said? It doesn't matter what you were actually sentenced to. If you plead guilty to, or you're found guilty of a crime where it's labeled a felony by the state or the feds, and you, under that statute, could have been sentenced to more than a year in prison, that is deemed a felony and you lose your gun rights for life. Likewise, if you are convicted because you pled guilty to, or you were found guilty after a trial of a misdemeanor where you could have been sentenced to prison for more than 2 years, even if you weren't, you lose your gun rights for life. You hear what I just said? So here you have a situation where if a state passes a law that says if you are caught jaywalking, you could possibly go to prison for 5 years. Even though no one in the history of the state, let's say, has ever gone to prison for a day for violating that jaywalking statute, if the legislature said you could be sentenced to up to 5 years in prison for jaywalking, that would be deemed a federal felony for the purposes of what is a felony under 18 U.S.C. 922 G1, and you would lose your right to keep and bear arms for life for jaywalking because the statute provided for over a year or over 2 years of prison time, even if you were never actually sentenced to a single hour in prison. That is why this federal statute is overly abused and loved by the anti-gunners, because it allows all sorts of people that should not lose their Second Amendment rights to lose them because of the overly insane broad definition of felony under the statute. Now, just to show you how extensive that is, according to the Duarte decision, they cite statistics here. Are you ready for this? Today in America, there are former felons between 19 million and 24 million. You hear what I just said? 19 million to 24 million people have felonies as defined by the statutes, or these federal statutes, right now. Now, how many of these are doing something nonviolent and stupid when you were 19, 20, 21 years of age, which I don't condone doing stupid things or doing crimes. I don't condone that. But how many of these are mala prohibitum crimes, meaning a crime that is just a crime because the legislature says so, there's no evil intent or anything of the like? And how many of these people are felons, even though they never served a day in prison because they didn't do anything particularly bad, but they pled guilty or they were found guilty of some crime that could have resulted in a year or 2 year prison sentence, which would qualify them as a felon under this federal statute? It's a pretty big number. Now, of course, the anti-gunners love this because they like to say that means there's 19 to 24 million Americans that have no interest in preserving their Second Amendment rights because they can never touch guns. So how many voters are in that cohort in support of the Second Amendment that are not interested in the right to keep and bear arms because they cannot touch guns, even though they're nonviolent felons? Now, again, we're not talking about violent gangbanger terrorist thugs that have engaged in murder and mayhem that violate in malum in se laws. We're talking about these malum prohibitum laws. I believe, for example, the Duarte individual, when he was a young man, engaged in a couple acts of vandalism. I don't condone vandalism, but the reality is, people do stupid crap all the time when they're young, especially when they're young, and why they should lose their right to keep and bear arms for life because they did some stupid stuff when they were 20, 21, 22 years of age. I'm sympathetic to them. As you get older, you do mature. I know I certainly have gotten more mature and behave better now than I did when I was much younger, and I think we're all in the same boat. So the only other point I want to make here is, again, once the person's, the other types of conduct, remember, it's the people, who exactly is the person that wants to exercise the Second Amendment rights? What is the arm involved? And the last is the proposed course of conduct. Now, there's other types of courses of conduct that can be involved with the Second Amendment. One is simply to possess arms, which is like the Duarte. Some of it may be I want to make my own gun. Some of it may be I want to buy a gun. Some may be I want to shoot a gun. Some it may be where I want to carry a gun. I want to carry the gun into the church, or I want to carry a gun into the post office for self-defense. All of these sorts of things involve a proposed course of conduct involving firearms. And of course, that implicates the text of the Second Amendment. So it's very, very easy for the text of the Second Amendment to be implicated. I should also know one other interesting thing about this Duarte decision by the Ninth Circuit is they specifically said that it's unclear as we sit here today in American law whether or not the burden is on the plaintiff or the person supporting the Second Amendment rights, whether or not the burden there to satisfy the plain text. I presume that the right answer is that as a matter of pleading, an assertion, you have to assert that your Second Amendment rights have been implicated. I think that's a very, very easy thing to do, to say, hey, I'm an American citizen. Hey, I want to have a gun, or I want to carry a gun, or whatever. And that's an arm. And of course, I want to keep my gun, which is to possess, or to carry a gun, which is to bear. Pretty easy to assert that and to trigger the burden shifting to the government to come forth with a long-standing, unbroken set of laws to show that whatever they're trying to ban or prohibit today is consistent with the historical tradition of firearms regulation in this country. Very hard for the government to do because at 1791, there are very few gun-related laws on the books, which makes sense because the same people that adopted the right of the people to keep and bear arms shall not be infringed are the exact same people that would have been passing these anti-gun laws. So why on earth would they be passing anti-gun laws at the same time they're preserving the right of the people to keep and bear arms in the Constitution of the entire country? That doesn't make any sense. So the fact is that there are very few laws at the time of the founding regulating gun ownership is entirely consistent with the ultimate history of what our founding fathers thought about this right, which is just so fundamental they put it in the Bill of Rights. So the fact that you don't have gun control laws and you have that sort of silent vacuum makes a lot of sense. There's nothing crazy about that at all. In fact, it's entirely consistent with protecting the right. Why would you be legislating and restricting the right at state laws, at the state level, and so on, while at the same time making it one of the most important national rights preserved by the new Constitution? It doesn't make sense. So that's why it makes a lot of sense that you'd have no state laws or very few state laws regulating gun ownership, at the same time these same people adopting the Second Amendment. That history is entirely coherent and makes a lot of sense. All right, folks, hope you learned a little bit something here today about this Duarte decision and how to break down the Bruin case and the text of the Second Amendment. We'll talk more about this in future videos. Don't forget to subscribe to me on X at 4Boxes Diner. And yes, I'm in a suit because I was just on Fox News. That's just how it's going to be this year. And don't forget to subscribe here. And we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.